Welcome to Reclaiming Our Right to Breathe. This is the first in a series of webinars EBC will host on the topic of criminal justice reform. My name is Anthony Trufant, and I'm the senior pastor of EBC, where I've served for almost 31 years. Today, I have the privilege of serving as one of your co-hosts, and I assure you, we will make very good use of your time. At EBC, we don't run from hot topics in the public square, nor do we stick our proverbial heads in the sand. We understand we have a sacred obligation and a unique opportunity to host experiences that cut through the myths, clarify the meaning on confusing issues, and provide actionable steps based on the panelists' advice and comments of the participants. The coordinating team and I have kept our ears to the ground. We have discovered an ever-growing chorus of criticism about the criminal justice system that shows a bias in how people of color in general and Blacks in particular are handled in comparison to how whites are treated. Therefore, we contend a conversation is warranted on how people of color can understand and navigate the criminal justice system. In effect, we want to access information that will help us secure better results in terms of mental health services for EDPs, that's emotionally disturbed people, rather than incarceration, no sentences for the innocent, and punishment fitting the guilty's crime. When we think of high-profile cases like the Scottsboro 9 and the Central Park 5, or cases that are less known, like Jamal Truelove, who spent 6 years in prison for a murder he did not commit and for which police framed him, or Cetonia Brown, who was released from jail early for a crime for which she never should have been jailed in the first place, or Marcus Dixon, who was an honor student and highly recruited high school football prospect, whose only crime was dating a white girl whose father didn't like the races mixing. Then there is Tyra Patterson, who was 19 years of age, a good Samaritan, yet illiterate, who was pressured to confess to a crime she did not commit and spent 23 years behind bars. We thank God for organizations such as the Innocent Project, the NAACP Legal Defense Fund, and the AFL-CIO, to name a few, that continue to fight for the rights of the incarcerated. Also, we're indebted to criminal attorneys who take on cases for free and corporations whose staff are obligated to do a certain amount of pro bono work annually. Today, our primary focus is not to correct the structural, procedural, and legal dimensions of the criminal justice reform. That is for one of our future conversations. Today, our focus is on learning practical strategies, helpful workarounds, and proactive steps that we can take when caught up in the criminal justice system. As always at EBC, we begin every experience by bathing it in prayer. So I want to invite Reverend Stefan Weathers, who is the Associate Pastor for Youth and Young Adults, to lead us in prayer.
Amen. Let us pray. Abba Father, our Mother, eternal Creator and Master of the universe, we are thankful and humble about the beauty of life. We come to you today as people who want to talk about, want to engage, want to be involved in creating a better, a greater justice system in our country, a justice system that is not always just to everybody in the same ways, Lord God. So we pray that on today as ordinary community members, as clergy, as community leaders, as elected officials, we can have a meaningful, impactful conversation, that we can push the envelope, push forward, Lord God, with a mindset, with an agenda, with a purpose and a cause, Lord God, on improving, not only helping people navigate the criminal justice system, not only helping people navigate the systems, but also seeking to change where change is needed, seeking to restructure where restructuring is needed, seeking to transform where transformation is needed, so that truly our justice system is guided first by human dignity, and mercy, is also guided by the principle of love, is guided by the principle, of course, of justice and equal justice dispensed equally to all. We ask this and we pray this in the mighty name of Jesus, the one who came into this world, the revolutionary for love, who came into this world to give sight where there is no vision, who came to bring good news to the poor, who came to set captives free, who came to provide liberty to the oppressed. This is our prayer in Jesus' name. Amen.
My co-host, Ms. Jocelyn Walters, is a smart, strong, and very spiritual sister. Jocelyn is a sister who holds in dynamic tension characteristics that some might think don't go together. For example, she is the daughter of a law enforcement professional, and at the same time, she has an unabiding and unquenchable drive and passion for justice. She is a member of the Total Praise Choir and one of the featured soloists. And she is also the head of Impact, the EBC social justice ministry. Her heart is in Brooklyn, but now her home is in Washington, D.C. Today, she proves that she has been able to effectively make the transition from being an on-campus member in Brooklyn to being an online member in DC. Without further ado, Jocelyn, take it away.
Thank you, Rev. Thank you for that wonderful introduction, Humboldt. I'm delighted to be here today to connect with all of you and also represent the Impact Ministry and the church as a whole. I'm going to start out with some introductions and then go into a conversation with some of our panelists, and then we'll go into some Q&A. So again, delighted to have all of you here. And I'm going to start with our introduction of our very own Leticia James. She serves as our Attorney General for New York, the state of New York. She also is a native to Brooklyn and a Howard grad and a Lehman College grad. And she previously served as the New York City public advocate, where she basically transformed that whole role before she left it in other good hands. And in her AG capacity, she has created new innovation, including the Conviction Review Bureau to address issues of wrongful conviction across the state. She's led the charge on the opioid crisis, and she's worked with DA Gonzalez, also on this panel, to take guns off the street. And we are all waiting with bated breath to see the work that she's going to do in relation to Donald Trump. So we appreciate her in so many ways, and we look forward to seeing more of the good work coming from her office. Second, I want to recognize Congressman Hakeem Jeffries. He serves as the U.S. representative for New York's 8th congressional district, which includes both large parts of Brooklyn as well as Queens. He too is a Brooklyn native and on his 4th term in Congress. He cares about issues and forwards legislation around social and economic justice, healthcare, and education and social justice. He recently passed legislation to provide entrepreneurship counseling and training for formerly incarcerated individuals. He's led the effort to pass the George Floyd Justice in Policing Act to criminalize chokeholds and other tactics designed to endanger people. And he is a primary component of the First Step Act, which retroactively provides relief for harsh sentencing due to the disparities related to crack cocaine convictions. And that's included reentry effort funding, as well as support for women who are pregnant during incarceration. So we're grateful for your time, especially on a Saturday. So thank you for being here. And then I also want to introduce DA Eric Gonzalez. He has been a great partner in a lot of different efforts. We've been on a few different things together in relation to the Impact Ministry. And so I appreciate him being here as well. He also is a native of Brooklyn and has been the DA since 2017. He's launched initiatives on bail reform, youth court, pre-court diversion programs, as well as inequity in immigrant consequences related to legal action. His major platform is called Justice 2020, which includes 17-point action plan to promote fairness and restore trust in the justice system. And he's also been working with his own department to increase the diversity in employment in his office. So we thank you for being here as well. And then also, I want to introduce Assistant Prosecutor Sherry Stembridge. She is in the New Jersey Essex County Prosecutor's Office. She has a long history in the legal force, working both in New Jersey and New York. She also is a member of Emmanuel Baptist Church and got her degree from South Carolina Law School. So those are our panelists today, as well as Roosevelt, Sears, and Ruben Rivers, who I will introduce now because I want them to give their own overview of their background. So I'm gonna start with Ruben, and if you, Ruben, could talk a little bit about your story and how innocent parties can get wrapped up in the system. And if you could give us a little color, that would be wonderful.
One second, please. Hi, can you hear me? Let me begin by saying that it is an honor to be able to come up here and tell my story, but I'd like to take you on a journey of a young man who was raised by his aunt and uncle in Bed-Stuy, Brooklyn, who had the ability to do so many things and did do so many things, but got caught up in the street activities of being addicted to crack cocaine. I was addicted to crack cocaine for a number of years, and once I got into recovery up in the Bronx at a program called Promessa, they really helped me up there to stay clean by introducing me to Narcotics Anonymous. And during my addiction, I had a real bad spiral downfall, and I slept in the Port Authority, I panhandled, and I did a lot of things I wasn't too proud of to get my drugs. And consequently, it was very destructive. However, I turned my life around and I now have 32 years sobriety. I was able to start working in the fashion industry where I became a casting agent. And I used to cast models for Fashion Week shows, things of that nature. I lived in, and a young man that lived in my building had got shot, and I was preparing a memorial outside the building to see my ID. I said to them, "Why do you need to see my ID?" And they said, "We just want to ask you once again, can we see your ID?" So I showed them my ID, and they said, "Oh, okay, no problem." And they left. So I paid it no mind. I went to work that Monday in the city, and I was at work, and those very two same detectives came into my job, and they said to me, "Can we step outside? I have a question for you." So I stepped outside in the hall, and they said, "Someone has accused you of rape, and we'd like to just take you downtown and ask you a few questions." And I said, "Why do we have to go downtown and answer questions? Why can't you ask me right here?" They said, we just want to take you downtown, just to make sure we get everything that we need. We're not even going to handcuff you because you're not under arrest." So I said, "Okay, I'll go with you." I walked back into my office and went to my desk and started picking up some things. And they said, "Is that your laptop?" I said, "Sure." They said, "We're going to have to take that with us." So they took the laptop and they took me to a precinct in Brooklyn over on Grand Avenue. And they put me in a cell for like 3 hours, but I could see what they were doing in the process. They were going through my computer. They had came over and asked me for the password, and I gave it to them. And they started going through my computer. And then they came back and they said, "Well, you're being accused of assaulting someone sexually, and we want to know if you'd be willing to take a DNA test." And I said, no, I'm not taking a DNA test. I said, and y'all need to tell me why I'm here. Long story short, they wound up coming back and arresting me the same day as I was in the bullpen. And they said, we're placing you under arrest. We're going to take you down to central booking. They took me to central booking, and I wound up staying in central booking. It was a Thursday. I stayed in there till that Monday. And then I finally saw a legal aid lawyer came in, and she said to me that I'm not here just to be a lawyer. I'm here. I'm just here so I can find out what your plea. What are you pleading? I said, but let me tell you what happened. She says, I don't need to know what happened. She says, are you pleading guilty or not guilty? I said, not guilty. She said, all right, the judge is going to ask you when we go outside. Just tell him you plead not guilty. So when we get out to the judge, I said, not guilty. And they said that they didn't want to give me any bond, but then they did. They made it $100,000. So I didn't have $100,000. So they arrested me and they took me to central booking. And I went through the whole process of central booking. Long story short, I wound up being incarcerated at Brooklyn House I went to Rikers Island first for a couple of months. And then they took me out of Rikers Island and took me to Brooklyn House. And while I was in Brooklyn House, I had a few incidents with a couple of guys, and they put me in the box. And while I was in the box, I got sick. And then when I got sick, they took me to medical, and medical told me that there was nothing wrong with me. But then I wound up catching pneumonia. And by the time they caught it, it was too late. They had to wind up taking me to the hospital, where they handcuffed me to a bed while I was in the hospital. And when I came back, they put me downstairs in another cell down in the basement until someone came and got me and took me to Rikers Island. When I got to Rikers Island, they put me in a dorm that was very violent and a lot of gang members and things of that nature. And it was very rough. In my time being incarcerated at Rikers Island, I found that a lot of the correction officers weren't very nice. I would tell them that I wanted to make a phone call. They wouldn't let me make phone calls. I was telling them that I didn't belong in the place where they had me because I wasn't a bad person. And I wound up getting into fights trying to not be sexually assaulted, which didn't pan out too good. So eventually I went to court and they started giving me adjournments every 90 days. So I had an adjournment for 90 days, adjournment 90 days. And I had a lawyer, I don't know if I should say her name or not, so I won't. But she wasn't helpful at all. She was a legal aid lawyer. And what she said to me the very first time we talked is, she said, I'm going to be honest with you. She says, you're not going to win this case if you take it to trial because you have a lot of things against you. You're Black, you're gay, and you're old. Those all play a major factor. So I think you just need to plead out and, not waste any more time. I'll see what I can do as far as the time is concerned, but you will be registered and, all of this stuff. And I said, no, I'm not pleading guilty to something I didn't do. And you still haven't told me if they have my DNA, who's saying that I did these things to them. And there was a whole lot of stuff answers I wanted that I didn't get from my legal aid lawyer. And it took them, I had like maybe 6 or 7 adjournments, which left me on Rikers Island for almost a year and a half with adjournments. And I stayed in Brooklyn House for almost half a year with adjournments. I finally got a court date and she came to me and she said, it's not looking good for you. Are you sure you don't want to plead guilty? If you plead guilty, I can get you a lesser charge. And I was just tired, so I pleaded guilty. And when I got before the judge, they gave me time served and 5 years probation. And they recommended me to a program that I had to attend. I did the 5 years and I was released in June of 2015. And I just thought that the system could have did a better job for me because I really didn't have anyone to represent me the way I needed to be represented. I was kept in the box on numerous occasions. And On 3 occasions, I had to fight to keep my manhood, which turned out kind of not in my favor. So I just wish that the system would just did a lot better, That's all. I want to thank you guys for listening. I hope that my story can help somebody not have to go through the process of getting a legal aid lawyer who doesn't want to do their job because they're up to become a judge. And she is now a judge from my understanding. And I just felt like it could have been handled a lot differently. I mean, $100,000 for somebody who has never had anything like that happen to them before. I thought that was crazy, but that's my story. Thank you for your time.
Ruben, thank you. I mean, I can't imagine, even with the color that you provided in your story, what that was like. And I can't thank you enough for being brave enough to share with us your experience. And I too hope that as part of this conversation and also the future endeavors of those on this panel, that there can be more done to prevent anyone going through what you experienced. To start with the question, the obvious and open question is, I would love for some of our panelists to talk about how the system failed Ruben's case, within mind, how the system is designed to work, and versus what has happened to Ruben.
Sure. Yeah. Hi all. First, let me thank Reverend Trefant and Emmanuel Baptist Church for hosting this. Jocelyn, thank you for your role in this, and to our great Attorney General and our great Congressman, thank you for being a co-panelist with me on this important issue. And Mr. Rivers' case is so much about, and I want to thank him for sharing the trauma that he went through as he engaged with the criminal justice system. And so much of what he said is really the problems of equity in our justice system. Being in a situation where you don't feel that you're being represented adequately by your counsel, and not having the choice of your counsel, but also talking about the conditions that existed, in Rikers Island, how he was subjected to that trauma, how the brutality within Rikers Island has been a place. It's one of the reasons why I've been a supporter of closing down Rikers Island and creating safer spaces where people are treated with human dignity. That what his experience within Rikers Island should not happen to anyone. This was all happening even before there was any kind of adjudication of his guilt, and we just can't have systems that treat people without dignity and that brutality. And also, he raises the important issue as well of bail and the purpose of bail, and being set a very high bail without any options to get out. And all of those things are things that I'm working on as the DA in Brooklyn, making sure that our bail recommendations are fair, that we're not asking for bail needlessly, and that when we ask for bail, we are actually setting bails that we believe people can make. And if we think someone is really a public safety risk, instead of asking for high bail, asking judges to remand them based on the charge or the incident. And so these are things that we're trying to reform in our justice system. And what happened to Mr. Rivers, has happened. It was 10 years ago, nine years ago. It's still fresh, and these are really important pieces to what's the failure in our justice system and why we all have to be on the same page, because these issues really affect Black and brown communities more than others. 90% of the people that are held pre-trial on something that's not remand are people of color, and that becomes because of the issue of bail. So I've supported bail reform. I want to talk very specifically, though, to the challenge that Mr. Rivers had in court, without talking about the underlying facts of the case, and that he was in a situation where he gave up. that he pled guilty simply because he did not believe he could get a fair shake in the justice system, that his lawyers had told him he had no shot of winning. And while quite frankly, they should give their clients their honest opinion about the case and the circumstances and likelihood of success versus failure and getting convicted, no one should have to plead guilty because they don't feel there's an advocate on their side to hold the people accountable to proving guilt. And everyone comes into the system with the presumption of innocence. Mr. Rivers had a story that he wanted to be able to tell, and he was prevented from telling that because he really just gave up and felt that he didn't have a shot. So I think what's useful in this conversation is to say, if you're in that situation, there are ways to be heard. First and foremost, while clearly he could not afford private counsel, he was afforded legal aid. But even though legal aid may not be a cost to him, it's not free. Taxpayers are paying for legal aid, lawyer services, and if you think there's a lack of communication with your assigned lawyer, you can ask the lawyer to step off the case and get another lawyer appointed. If the lawyer refuses to do that, you can speak to the legal aid supervisors and ask for a reappointment of another lawyer. My experience is when a client asks for that, it's usually granted. And if that does not happen, you could ask the court to appoint a new lawyer. Usually the judges will. I would say 80% of the time I've seen the judges say, if you're not happy with your lawyer, especially in the early parts of the case, prior to the case going to trial, judges would reassign it, and sometimes either reassign it to another legal aid lawyer or provide a state lawyer, an 18B lawyer. And of course, obviously there's an option in who represents you. When you're facing charges, lawyers are a little bit like doctors. They're kind of generalists, but there are people who specialize in different areas. And so making sure, that you have a lawyer who's comfortable in handling a case that involves sexual assault or an allegation of rape. There are lawyers who aren't comfortable doing that kind of work. And if you have that kind of lawyer, you're not being well represented. You have to have lawyers that are comfortable in doing that kind of work. There are a lot of lawyers who say that's a red flag. Especially with a young child, they're not going to, get themselves involved in that kind of case. And so I think the system failed you, Mr. Rivers, in a lot of ways. I just want you to know that your story and the stories of others that I've spoken to in my career is why I'm trying to change a lot of the things in the system. And people ask me all the time, like, why did you support closing Rikers? And I say, because we can't keep people safe in there. There's so much brutality and so much violence. And why are you trying to, divert people out of the justice system? And I say, because the people don't come back better to our communities because they're subjected to so much trauma and so much things that when they come out, they don't come out any better, and very hard to reestablish your life. So I'm working on creating reentry programs and other things so that what happened to you, we're trying to address it very directly. So I think that's what I can contribute without directly talking about the facts of your individual case. But I do believe, and it's very important, and I think one other thing that I'd like to say is this pressure that people who are incarcerated are under to plead guilty to get a benefit, a plea bargain. One of the things that I've changed in my office is we don't do ballooning like trial penalties. We don't say the office 3 years, but if you go to trial and you're found guilty, we're going to give you 20. We changed that. And another thing that I've changed, and I think this really matters, is there are certain categories of cases where I can force a bench trial. I can not allow a defendant to get a jury trial, and we can force that trial to go before a judge, especially in a lot of misdemeanor cases. I've told my ADAs that they're not allowed to do that, that we will only do a bench trial upon consent of, the defendant and the defense attorney, that we will afford people jury trials at all times. And that was a tremendous change. I think I may be the only DA. I think maybe in the Bronx, they may be doing that too now. But I was the first DA in the state that said, we will not circumvent jury trials. We will give people the right to have their case heard before jury. So thank you, Mr. Rivers, for sharing all that happened in your case. And I'm glad to see that you're out and you've been reestablishing your life, and we can have further conversations offline.
Thank you. I want to give AG Tish and Congressman a chance to also weigh in there, but I also want to make sure we have time to hear from Roosevelt. So feel free to weigh in on this first question, and then we'll switch over and chat with Roosevelt about his story.
So thank you. First, I want to give honor to God for this afternoon's panel on criminal justice. I want to thank the angel of this great church, my pastor, Reverend Trufant. I also want to thank Jocelyn Mann and Jocelyn Walters. And I want to thank my fellow panelists, my Congress member, Hakeem Jeffries, my district attorney, Eric Gonzalez, and my co-panelist, Assistant Attorney General, ADA Steinbridge. And to Mr. Rivers, the system clearly failed you. And I think, let me start out by saying the obvious. Racial disparities affect or infect every aspect and every stage of the criminal justice. And all you have to do is be a student of history to recognize that race and policing, there's an intersection between race and policing all throughout the history of this country, and there's no denying it. If you analyze the number of stops, the number of arrests, convictions, and sentencing, there's a disparate treatment of people of color, and no one can deny that. Two, I think it's important that whenever, because of the over-policing of our communities, it's important that individuals know their rights, which is why I'm glad my church is holding this event today. It's important that individuals recognize that having a competent attorney is really critically important. I am a former legal aid attorney, but I retired after 4 years because I was burnt out. And there are too many legal aid attorneys who are still in the system who really should be retired because they churn plea after plea after plea after plea. The other thing that I want to say is, again, whenever you are confronted with an officer, you've got to demand that you have an attorney. You've got to contact someone in authority. And three, and then my last point is that, we are moving this system and changing this system. I want to thank Congressmember Jeffries again for sponsoring the George Floyd Criminal Justice Act that Democratic Attorney Generals obviously have supported, and we want to be a part of that act because we too want to investigate pattern and practice cases like the Department of Justice. It's also important that we be smart about policing, that we use more technology, and that individuals have access to look at their DNA, to inspect their DNA, so that we can go to trial, and again, so that more individuals can be innocent, because there are a significant number of individuals in the criminal justice system who unfortunately are wrongfully convicted. And so, Mr. Rivers, again, on behalf of the state of New York, I just apologize. We do not have, in response to Reverend Trufant's question, there is not an expungement law in the state of New York. They seal it, but right now they are working to expunge records, but unfortunately there is no expungement law in the state of New York.
And let me just also add a word of thanks to Reverend Trufant for always convening us in such a forward-looking and visionary fashion, and for what Reverend Trufant, of course, has done for the church and for the community on so many different issues, whether it's housing justice, racial justice, criminal justice, reform. To my distinguished panelists, of course, my sister, Tish James, our Attorney General, and my brother, Eric Gonzalez, the DA. Also, I want to thank you, Jocelyn, for the tremendous work that you do in this space, combining faith, ministry, and justice. Let me just simply add to our Attorney General and our District Attorney briefly, so we can hear the next story of one's journey through the criminal justice system, which is so compelling, that some of the challenges that we confront are highlighted by the story that was told by Mr. Rivers. One, the system is designed for there to be a presumption of innocence, innocent until proven guilty, theoretically. But in practice, structurally, it's guilt unless you can prove that you're innocent. And that is a perversion of the most fundamental principle of what our system is supposed to be about. And in order for us to transform that, there are several steps that are going to have to be taken. One is to make sure that we're providing counsel, which is a constitutional requirement under the Bill of Rights, that is effective and capable, not overwhelmed and under-resourced. And so there are structural changes that need to be made in terms of criminal representation so that everyone, even if you can't afford a high-powered private lawyer, has the opportunity to fully and robustly defend yourself. And so that's going to be critical as we move forward. As the Attorney General indicated, we also need to make sure that our young people in particular, as my father told me growing up in Crown Heights in the middle of the crack cocaine epidemic with a lot of aggressive policing, never respond to anything that a police officer has to say to you. Never answer any questions. Immediately ask for a lawyer or ask for your parents. Because as we found out with the Central Park 5, now exonerated 5 case, forced confessions can take place, coerced confessions occur. One individual is pitted against another individual. Promises of leniency are made, and under law, the police can actually lie to you while they're interrogating you. They can lie to you as a strategy without consequence. That has to change. The other thing we're working on is just changing our sentencing laws, as we've begun to do, and striking a blow against mass incarceration with the First Step Act that was passed into law in 2017. That was a first step. There's much more that we are working on with our new president and our vice president, Kamala Harris, who was a leader in criminal justice reform when she was in the Senate. And lastly, I'll say that one of the things that encourages me is that we have taken steps to elect enlightened public attorneys and prosecutors, like our Attorney General, Tish James, and our District Attorney, Eric Gonzalez, and before him, our District Attorney, Ken Thompson. That was an intentional step that all of us have taken to put people in place who share our life experiences, share our sensitivities, are open and accessible, like our DA and Attorney General today, to have a conversation with the community and to ensure that the right thing is done moving forward with respect to our criminal justice system. And so I thank you for giving me an opportunity to participate, and I look forward to the continuation of our discussion.
Thank you. And I want to give Assistant Prosecutor Sherry a chance to weigh in on this as well.
Thank you. And I would just say hello to everyone, and I'm glad to be a part of the panel. So I'll provide briefly the New Jersey perspective. So in New Jersey, as of January 1st, 2017, the Criminal Justice Reform Act went into effect. And basically, this is supposed to, it eliminated cash bail for these kinds of cases. So Ruben, what happened to you as far as, you know, what a bail of $100,000 being set, you know, that doesn't happen anymore. And so what happens now is that we have, when a person gets arrested and they're seen before a judge within 2 days. So at that time, there is what's called a public safety assessment that's done. And basically the judge has to make a decision as to whether the charges are serious enough for the person to be released, and also whether the likelihood of that person returning to court. So that those are now the new factors. And what's been happening is that most of the people who would have sat in jail for months before, they're now actually being released. And they're being released with certain conditions. So level 1, anyway up from level 1, which is basically a phone call reporting into for your case about once a month, to basically home detention with electronic monitoring. So I think that's been a big thing that I think has made the most practical impact as to what's happening in New Jersey. And then also just a little further on down the line, when it comes to evidence, like Ruben mentioned, he didn't know what the evidence that was used against him. When we go to court on status conferences for cases, the judges will ask, well, what evidence do you have or what's missing? And I can just say in my experience that we have to show, or at least be able to proffer what we're offering for these cases in order to move forward. And if we're not doing that, then, we have to reevaluate. One, is it even a good case in the first place? And then, 2, is it what, you initially thought the case was? Is the charge really what you thought it was? Or is it something less? And, that happens all the time too. So, as prosecutors, we have a duty to make sure that the evidence is what we're being told it is. And if it's not, then, we have to dismiss the case, which, I do. You have to talk to your officers, you have to talk to your witnesses to see what you have. And if you don't have, the evidence, then you dismiss the case. So in Essex County, I think, it's a little different because the majority of the cases in the whole state of New Jersey come out of Essex County, but that's our practice as of 2017 when it comes to those cases, especially with, no cash bail.
Thank you. And so I want to just say that there are so many good questions that have come out of everything that was said so far. We're going to let our other panelists share his story, but we are going to go back into a number of questions, both for the panelists and from the Q&A. So with that, I want to turn it over to Roosevelt Sears, who's going to share his story, and then we'll come back with some questions, and then we'll hopefully have some time for Q&A.
Before Roosevelt shares his story, I would simply want to share a take on Roosevelt. Roosevelt has been a part of the ministry for several years, and he came initially as a member of our operations staff, our custodial staff. And after being here for a while, he resolved to take a step forward and deepen his relationship with EBC by becoming a member. And he then took an additional step and became a member of our men's ministry, the Frontliners. One of the things I've always appreciated about him, among other things, is that Roosevelt has told me repeatedly how grateful to God he is for the opportunity to start over and to rebuild his life. And I want to acknowledge his humility. I want to acknowledge his faith in God. And I want to acknowledge the fact that his journey into the criminal justice system began when he was a teenager. And he's going to share with us more about that story. But I've known people who have been in as long as he has, who A, come out and they are bitter, B, come out and they are dysfunctional, and C, come out and often go right back in. So I just want to salute him and to ask Roosevelt, will you share your story?
Can everybody hear me? My name is Roosevelt Sears, and I was hanging out with two friends, and these two friends of mine had jumped on somebody. So as they jumping on this guy, I'm looking like, what are y'all saying to myself? What are they doing? So they jumped on the guy doing whatever they do, they doing what they doing. and all of a sudden, you know, the guy falls and they run. So I'm looking like, okay, they running. I ain't running because I ain't, you know, I ain't doing nothing. So I walked away. A couple of months later, the cops is calling my job, saying that you was involved with a murder, such and such and such. So I'm like, I wasn't involved in anything. So they said, well, you'd like to come down to the precinct. So I'm like, come down to the precinct for what? I didn't do anything, you know. So long story short, I went home. They had arrested me at home. So they took me down to the precinct, and I'm going through, they questioning me about this murder. So I'm like, I didn't do anything. Well, who is these guys? I'm like, okay, I don't know who these guys are, you know, 21, you know, I'm young, I don't know, you know. So I'm like, I don't know these guys. So they put me in a lineup, and I'm dark. I'm the only dark guy in the lineup. So they supposed to have this person pick me out. So they arrested me. I'm going back and forth to court. But prior to that, the same two guys who did the crime, they had got caught for something else. So now that's when I guess they told that I did this, I did that, I did this. So now as we go into court, I go to court, the judge is like, yo, my lawyer was saying that my two co-defendants is testifying against you, that you was the mastermind of it, you was the one that did the murder, they was watching, but I'm telling my lawyer, no, I didn't do anything. You know, I didn't do anything. We was supposed to hang out, they jumped on this guy, they killed the guy. I didn't do anything. I didn't touch the guy, I didn't do anything. So keep going back and forth to court, back and forth to court. So now the judge is telling me, yo, they want me to cop out the 15 to life. I told my lawyer, I'm not copping out the 15 to life because I didn't do nothing. I didn't kill this guy. Why would I cop out the 15 to life for something I didn't do? So so we keep going back and forth to court. We going back and forth to court. So now now we get ready to go to trial. But I'm saying to myself, I'm like, yo, I may not have no wins in trial because my lawyer is not really like helping me, like, you know, and I feel that if I go to court and if I go to trial, I blow trial, I get 25, 30 years to life for something I didn't do. So I'm weighing all those options, like, you know, and I'm like, this is not fair. It's like, yo, I'm angry because I said to myself, I should have never been with these guys, number one. But these guys got me in a situation that I can't get myself out. So we're picking a jury. So all of a sudden, the judge, the DA come up with a plea, like come up with not a plea, but come up with a deal. Like, yo, we give your client 10 to 30 years. So I'm like, man, I ain't taking that. But then I thought about it. I'm like, yo, I can't go to trial for something I didn't do and get 30 years to life, you know? And what I did, I just wound up taking the 20, I copped out to the 10 to 30. And I was angry for doing it because I know in my heart, I didn't do it. So now I'm in jail doing all this time for something I didn't do, you know? But, you know, I did the time. I did almost 22 years. I did the time. I came home. I was in a halfway house. I went after the halfway house. I stayed in the halfway house for about a month. Then I went to Ready Wheeler Neighbor in Brooklyn on Gates Avenue. So I figured, I said, you know, that's my way of getting in to get all the things that I need, my driver's license, my OSHA's card, maintenance certificates, everything I needed to steer me in the right direction. Because my thing was, I'm not going back to jail. I wasn't going back to jail. So I graduated from the program. I went to like 35 interviews, job interviews. Nobody wanted to hire me. So the job developer said, yo, it's a church called Emmanuel Baptist Church on Lafayette St. James. They have an interview. Won't you go? I said, church? He said, yeah, go to the church and do the interview. So I did the interview, and a couple of months later, the church hired me. And, all that time that I went through job search, God led me there. He led me there for a reason. Nobody else wanted to hire me but Emmanuel, and Reverend Trufant and our executive pastor Sharika Newton. They gave me a second chance. But it's ironic for me that I did all this time for something I didn't do, and I didn't want to cop out. I really, really didn't want to cop out, but I just didn't have confidence in the system going to trial saying that I can win, because my lawyer gave me no confidence that we can win. So I felt I did the right thing to take the time. But, when I was incarcerated, I was mad. I was angry because I took the time, but I was like, yo, you know what? You put yourself in that situation that you should have never been in, because you should have never been with these guys, And it's a big lesson for me that I did almost 22 years, in prison. 21, come out 43. And it's and I always try to explain to a lot of guys is that the system, for me, it wasn't geared to reform. Because when I went in 91, you had all the colleges, you had all the vocationals and everything. It was geared for that if you was coming home within, from 91 to 95. But anything after that, it wasn't no reform after that. You had to basically reform yourself. And that's what basically I did. I said, I'm going to reform myself. I'm going to come out better than what I came in. And that's exactly what I did. And I kept that attitude. I've been home now 11 years. January 11th, make 11 years. I came home, I had over 10 years on parole. I did 3 years on more parole, and, I'm just thankful for Emmanuel for giving me the opportunity to work, share my story, because I feel my story needs to be told, because people need to hear. Because a lot of people are scared to say they've been incarcerated, and share their story, So I'm just grateful to be on this panel to share my story with everyone. I just wanted to, my birthday is next Saturday, so I'll be 53. So, I'm blessed. I can't complain. I'm blessed. So with that, thank you.
Thank you, Roosevelt. I can attest to Roosevelt's demeanor and his outlook on life. You would never meet him and think he's someone who is hard up on life, despite what he's been through. And so, Roosevelt, I commend you again, not only for sharing your story, but the way that you chose to look at life after that type of ordeal. So many questions come up for me around the sort of conversation being about how much time should you serve, not the conversation about whether or not you're innocent. That to me is just mind-blowing. I want to direct the first question to Sherry to talk a little bit about, from her perspective, again, what should someone do in a similar circumstance where you are in the wrong place at the wrong time, you're either with the wrong people? How do you navigate so that you can have a better outcome? Because this can happen to anyone.
So with any case that we have, and I'll just repeat what I said earlier. At the end of the day, you have to be able to prove, you should be able to prove what, what a person is being charged with. So that's the first thing. So whenever I get a case, there's an evaluation process that occurs. And, you have to look at your evidence. You have to review your case file. You have to speak to officers. You have to speak to witnesses. And then, again, find out what you really have. So as an example, so earlier back in March, I had a case where the person was actually detained. So as I mentioned earlier, whenever you have the more serious cases, it's more likely that that person would be detained based on, certain factors, public safety assessments, those kinds of factors. So this person, he was a high school kid, only just turned 18 in January. And we had a video that the detective was saying that was how he linked up for a robbery charge, to charge this person with robbery. So the attorney reached out to me, and this was early on in the pandemic. So, courts had shut down, and we, not shut down, but we were moving at a much slower pace. So the attorney presented information to me and, basically an alibi, and said, look, this person, this video that you have, or what the detective is using is not, this is not my client. If you take a look at that video and you see that the person in this video, and it wasn't the best video either. So that's another thing too, where it goes back to evaluating your cases. In the video, you can see that this person had like a really, really thick mustache, even though the video wasn't the best quality. This person, the guy that actually was charged, was 18, like I said, didn't have, any mustache at all. So what I told the attorney is, send me, some pictures from like the day of the incident, the day before the incident, the day after the incident, so I can, just go back and see, one, if this is your person, or not. So I went back, looked at the video, and you can see clearly that this person did have a really, really thick mustache. And when I discussed the case with, my supervisor, he's like, yeah, this guy has like a Magnum PI mustache, just to give you the visual. And so the teenager, he just had like a very, very small amount of facial hair, very, very small mustache. And so the attorney provided me with that evidence. I spoke to the detective. So, I explained to him, look, this is what I have. This doesn't appear to be the right person. So come to find out, the identification was made by a different detective who said that based off of the video, he thought that this was the person. But come to find out, based on what the attorney provided to me about his whereabouts and in the pictures, the day of, the day before, the day after, it wasn't, did not appear to be that person. So what happened is, at least because the person was detained, I was able to consent to his being released until, I was able to flesh out other things for the case. So, just to go back to it, we have to, as prosecutors, be able to prove prove the charges that we have. And we have to be, do our legwork and make sure that, we can actually prove what these charges are. And you have to, like I said, evaluate it. And once you've done a proper evaluation, then you can say, okay, yes, this person, did commit the robbery, because we, it's clear video showing that this is the person who did, the robbery. Or, you may have someone someone did commit the robbery, obviously, but it's the wrong person. So those things are very important. And, I just always say, bottom line, whenever I get a case, you just have to evaluate it, make sure that you are actually, charging the right person, and that you actually have, what the proofs, the right proofs. Like Denzel said in Training Day, it's not what you know, it's what you can prove. So what can you prove when you go, go to court? So that's the approach that I take to my cases.
Thank you, Sherry. I want to ask the other panelists a different question, but I do have a follow-up quick one for you. At any point in that example that you gave, are you required to show the evidence to the person that was arrested? I feel like in both Roosevelt's story, And in Ruben's story, they never mentioned when they got to see any of this evidence. When I think in Ruben's story, he didn't even know who he was being accused by. He was already locked up before that point. So could you just quickly shed some light on that? And then I have a different question for the other panelists.
So as a defense attorney, you are entitled to the evidence, but oftentimes you usually get the evidence right before trial. Discovery laws have changed recently. There have been reforms with respect to discovery laws in the state of New York. And so defense attorneys are entitled to the evidence prior. In the case of Mr. Rivers, obviously, as a defense attorney, I would have tested the DNA. I would have spoken or tried to get more evidence with respect to the complaining witness, whoever that was at the time. And see if there was any corroborating evidence with respect to the allegation of rape. In regards to my friend, Mr. Rivers, Mr. Sears, excuse me, Mr. Sears, who first of all is a blessing to Emmanuel Baptist Church. Each and every time that I attend the church, I see his smiling face, his warm disposition, and he's very, very pleasant. And so I just really want to thank you and bless you for all that you do. But I would hope that you would help me shovel my snow. Anyway, that's another point. So a couple of things. One, the criminal justice system is like a house of cards, and it would collapse if there would not be pleas. It cannot handle all of the cases in the criminal justice system. So if individuals who are accused of crimes, defendants as they're called, if they were not to take pleas, the criminal justice system would collapse on its face. It is a house of cards. It is built, again, to basically expedite as many pleas as possible. That's the only way that it can be efficient. Two, there's some concepts that have to be introduced into this discussion, particularly as it relates to Roosevelt Sears. And that is the concept of acting in concert, the concept of felony murder. What does that mean? And obviously the DA from Brooklyn is better versed on these subjects than I. But basically what it means is that if you are within a group of individuals and one individual commits a crime, all of you go down, whether or not you know it or not. And the question is whether or not you were aware of whether you were aware of that individual's intent. And you've got to prove that at trial, which I know is very, very scary. And then there's the concept of felony murder. In the consummation of a crime, if a felony is committed and it results in the death of someone, then again, all of those individuals acting in concert will be charged with the crime of murder. There are individuals who are seeking to change that. So in the case of, again, Mr. Sears, who obviously did not know the intent of these other individuals, would not be in a position to have been charged with that murder. And so what we need to do, again, as a church of conscience, as a church that's focused on justice, is to join in the effort to change that law, particularly as it relates to felony murder and individuals who are acting in concert. And there are some pending bills that are pending in Albany. Two, I want everybody to know, in New York State and in our country, the United States Supreme Court, and Congressmember Jeffries alluded to this, there's a case called Fraser versus Cupp, which basically allows police officers to engage in deception when they interview defendants in order to secure confessions. They are authorized under law by the United States Supreme Court to basically use deception and lies to get you to confess. There's a bill pending in Albany right now to change all of that, and that law needs to be changed. And I know Congressmember Jeffries, again, as part of the George Floyd Act, addresses that, which is why, again, we need to push on reform in the criminal justice system. And then, I was one of the first individuals to call for body cameras in the aftermath of the death, the murder of the gentleman from Staten Island, whose name is escaping me right now. And so, obviously it would have been in Mr. Sears' case with body cameras on police officers, Eric Garner, thank you. In the aftermath of Eric Garner, now all officers accepting specialized units wear body-worn cameras. Now, there's some issues with that. We don't have the time to talk about body-worn cameras, but obviously footage and video, street cameras, we have more street cameras. I was the city council member who put street cameras in and around the 35th district, which is Fort Greene, Clinton Hill, Prospect Heights, Crown Heights, to prevent this from happening. Because body-worn cameras and cameras in general, Argus cameras, et cetera, basically provide an objective view of street encounters, and particularly street encounters with police and street encounters in general resulting in crimes. And that obviously would have helped Mr. Sears. And again, trials are very, very scary things, particularly, again, when you've got co-conspirators who, again, want to save their own butts and they turn on you. And that's exactly what happened with Mr. Sears. They didn't have one case, they had two cases. And in order to clear their name and to get lesser sentence, what they did is they just turned on Mr. Sears. And so so when it comes to the rules of the road or rules of the street, you know, there is no honor amongst individuals on the street. And so Mr. Sears said it best, and that is he was at the wrong place at the wrong time. But unfortunately, the criminal justice system and the lack of basically technology and the lack of credible witnesses, unfortunately, resulted in him taking a plea, and because he was in that difficult position. But I am so glad that he's turned his life around, and I praise him and I thank God for all that he has done for Emmanuel and for all of us and for his story here today. Thank you.
Thank you. I want to give Hakeem and Eric a chance to respond to a slightly different question, but I also want to point out that we want to get to the questions from the audience right around like 1:12, hopefully. So the question I would like you to address that Tish kind of brought up is, when we think about the arresting officers and these idea of manufactured charges, falsified reports, I mean, you're really put into an imposition. You don't have visibility to what they know. So, and there may not always be a video clip. There may not always be a body camera on. So the police are allowed to more or less be the side of truth in these cases. So what should happen? What should people do to, again, put themselves on the upper hand of things when there happens to not be all this great video footage and information to go along with your presumption of innocence?
Well, I'll respond and then yield to our district attorney. But, you know, I think it's important that we pursue systemic reforms to front load the disclosure of information, as Attorney General James suggested and DA Gonzalez suggested. Steps have been taken in that regard in Albany and then by Eric's office on his own that are important. But we do need to change the landscape, as has been done in some regards, and there's more work that needs to be done so we can better even the playing field. That's a structural change that needs to happen, but an important one for all of us to continue to work on. The other thing is to, you know, just decline to talk to law enforcement until you secure the presence of an attorney. That's just a bright line rule. And it's unfortunate that we're in this circumstance, but we are, and that's just the reality. And that's what we have to tell our children, our boys, our young women, and our girls, particularly those who look like us, because the system is designed to jam us in many ways, and there are bad actors within the system. We have the right to remain silent. Exercise it. Exercise it. And then the other thing that I'd suggest quickly is that if you find yourself in a circumstance where you don't believe you have counsel that is adequately representing us, you know, contact your local representatives, either directly or through the church, through Reverend Trufant, who can get to us anytime, any place, so that we can step in. And, you know, as a councilwoman, Tish James would do that and reach out to the Legal Aid Society and work to secure adequate representation, or the Brooklyn Defender's Office. And I would do that as an assemblyman and can continue to do that as your representative. And take advantage of that. You're not on your own. We are there to work for you.
Great advice, Congressman. No one, and I say this as the district attorney, everyone should have counsel when they speak to lawyers. I'm going to go speak to the police. They should not walk in and think that what they say is not somehow going to be attempted to be used against them. And I think, we're astounded. We hear lawyers give Miranda rights, the police give Miranda rights, and people waive those rights because they want to prove that they're innocent, and they think that if they, ask for a lawyer, that's some sort of admission of guilt. It's not. You need to make sure that you have counsel with you. To Mr. Sears' case, there's so much to be said about this case. One of the things that I did in July is I released a report with the Innocence Project and with a law firm, Wilmer Heel, and we looked at 25 wrongful convictions that came out of Brooklyn over a 30-year period. It's entitled 426 years because that's collectively how much time these 25 individuals spent in prison. 24 were either Black or Latino. There was one woman and one white person that were wrongfully convicted. 3 of the men that were wrongfully convicted never got out of jail. They died in jail, to Mr. Sears' concern that if I take a 30 to life, if I go to trial, I could actually never get out. And so we have to think about all of these things, and to the thing that, Jocelyn even mentioned, which is the length of time. I've taken steps to change our sentencing guidelines. We have a bill in Albany right now to give people a chance to get resentenced, having shown that they're rehabilitating themselves in prison. I support that. I support other, parole bills to get people out who deserve to get out. But I want to talk very clearly about, the issue of wrongful convictions. 2.2 million people in jail. They estimate 4% of the people that are in jail are innocent. If you times 2.2 million by 4%, it's an outstanding number. And so we have to work. And, my office is doing work all the time on wrongful convictions. Our Attorney General talked about a very important concept, which is we have to talk to our young people about how factual and legal innocence play out. We talked about felony murder. We talked about acting in concert. Under the law, it does not take a lot to be included in a felony murder charge. Literally being with the people, taking any action that could be considered something that's a assist in the robbery. Could be as simple as standing up and blocking an eyewitness view, holding a door open. It could be almost anything that could lead to this conclusion that you had some involvement. And I want to say, in Mr. Sears' case, I tried to look at some old records. I mean, it's a really old case from I think 1990. There was no allegation in his case that he was in fact the stabber, that the other men involved, the boys involved, were stabbers. I also want to bring some dignity to the deceased family. He was a 35-year-old husband and father who was mugged and killed on our subway. And so what you saw happen is the police pieced together this information of who was responsible, and Mr. Sears, being 21 years old, probably not trusting law enforcement, not trusting that he would get a fair shake. He withholds information that could have, prevented him from, being implicated. And in fact, when his co-defendants get arrested, they implicate him. And then there are other, there's other evidence. And so we really need to talk to our children and to our young people about what to do in that case. And of course, as a congressman said, what to do is make sure you have a lawyer. But in this particular case, by the time, he's arrested, all they need is confirmation that he's present at the scene to charge him with a murder that he did not commit because of the rules of felony murder. And we need to really discuss this very carefully up in Albany about whether or not we still want to do that kind of approach, which is you don't actually have to be the person who kills someone to be ultimately held responsible for their death. But Mr. Sears, I am grateful again that you have been able to turn your life around and come out, as Reverend said, not bitter, but committed to God and committed to making the most of your life. And I'd ask all of you to think about the bills that we're sponsoring up in Albany from my office, really from a DA's office, to say we should be able to get people out. They don't need to be in there for 22 years for something like this. That sentence was very excessive. And so with that being said, if anyone has information about a case where someone is incarcerated and they think that they were wrongfully convicted, please have them contact my office. They don't even need a lawyer. On occasion, we will actually ask the court to assign a lawyer for them.
Okay, Mr. DA, before you shift gears here and we open it up to the audience, I have a quick question that's slightly beyond the scope, but is adjacent to what we've been talking about. If nothing else, January 6th showed us that there is indeed bias in policing. I mean, it was very clear in the event that happened at the Capitol. And the question that I have is, given that we know that there's bias and there was ample anecdotal evidence there, how do we account for the fact that there is bias and that when police are performing their jobs, they have a great deal of discretion. So they see something. We were taught that when they see something, that's stage one. They're just going to look at it and see if something's suspicious. Then stage two is engagement. They're going to go over and investigate. Stage three, they're making the decision to arrest you and put you in the system. My concern is that sometimes in the exchange between the police and youth, they get to stage three because the police officer feels disrespected. So how do you account? How do you deal with that then, given the scope of authority that they have?
Yeah, it's a great question, Rev. The issue really is fairness in policing. That we have to hold our law enforcement officials, our police department, our prosecutors, we have to hold law enforcement accountable for their actions. And we saw a lot of examples of, during the George Floyd protest and the report that our Attorney General released about policing systems and aggressive policing. But on the other side, on the investigative side, what my report really showed, the 426 report of wrongful convictions, is that police officers and prosecutors, but a lot of this stuff happens at the police level, have tunnel vision. They have a suspect and they don't evaluate evidence fairly, and they make up their minds very quickly in terms of innocence or guilt. They ignore evidence and discount evidence that suggests that people are actually innocent, and they lock on their theory of what proves their guilt. And that leads to wrongful convictions. And I think to the extent that sometimes we think they put their thumbs on the scale and coerce confessions or do things or suggest identifications that are not accurate, they have to be held accountable. We created a law enforcement accountability bureau in Brooklyn about 1.5 years ago. First time we've had that exactly in our office, and that really was to actually have prosecutors who no longer handle any other case, but simply look at bad policing and misconduct by police officers. And so I became the first DA in the state to release a public list of officers I'm no longer willing to work with. And a lot of those actually did not stem from misconduct in their personal life, but it stemmed from misconduct in their professional life. Saying things to prosecutors or in courts that were not accurate or may have been outright lies, claiming probable cause and having video evidence that countered that, and just said they've lied and that we can no longer trust them to bring us cases where they're the only sole witness in the case, or that we have to rely on their credibility. I'm not going to put them before a jury and make believe that the DA's office trusts them and then ask a jury to credit or discredit what they're saying. We're going to make a first cut at that. So we have a list now. We've never had that before in Brooklyn, where we're just saying we're not working on that. The other piece to that is, so those are just sort of an exclusion list. We're not going to call those witnesses anymore, those police officers anymore. The other thing is that we've put several hundred police officers on a disclosure list. We call it the Giglio disclosure list, but where we found credibility issues with them or prior bad acts, that we now say a defense attorney has the right to cross-examine in front of a jury so that a juror can actually determine this officer's credibility. That's how you get to the issue of police cheating or exaggerating evidence, by saying you will be held accountable. I can't fire a police officer. A lot of those things, as the congressman and the as Tish said, are actually legal. They can lie, they can deceive you, they can tell you your DNA is there, they can tell you they have 12 witnesses. So that's not something that they can be fired for, but we can disclose this information. And so we've unfortunately had to put well over 600 officers from Brooklyn on this disclosure list. And we're only, we've gone back about 15, 20 years. We're building that out. And so now within the first 20 or 25 days of a case, we're sending a letter to the attorney saying we have these disclosures about these officers, so that a person can make a better decision about whether or not the information that the officer claims was said to them or they witnessed is something that's reliable, so they cannot plead guilty if they know there's significant issues with the police officer. And for me, we're just not willing to call the ones we catch lying to us.
Thank you. It seems to me that at a certain point, we're going to have to introduce legislation that permits potential defendants to videotape their encounter with the police. They're supposed to be able to do so, but oftentimes, unless someone else is there videotaping, the exchange is not caught on camera. And then in a number of cases, the footage from the video cam is not released in a timely fashion so that attorneys can see it. I'm going to now defer to the other Jocelyn, Minister Jocelyn Mann. Jocelyn?
Yes, hello. In the interest of time and for control, we're asking that everyone please submit your questions via the Q&A panel, and because we're not going to be able to have people to ask their questions live at this time. And we intend to continue in the spirit of decorum and respect that the event has been conducted in. So if your questions do not align with that, they will be dismissed. And if necessary, you can be escorted from the webinar expeditiously. With that in mind, I would like to start with the first question from one of our panelists, actually from Ruben Rivers. He's interested in knowing what recourses and resources can he have to help him get justice for the sexual abuse that occurred to him when he was incarcerated, because all of his write-ups to the warden were never answered or acknowledged.
Well, I'll take that. I mean, we've recently amended the laws on sexual assaults that provide, that have taken away some of the procedural bars that prevented cases from being prosecuted after the passage of time. So it's very likely that while these may have been, 8, 9, 10 years ago incidents, that they're very possible that they could be prosecuted. So I don't know if it happened in the Brooklyn House of Detention or in Rikers Island. If it was in Brooklyn House, my office would be the person that could help investigate that. If it happened in Rikers Island, it would have to be the Bronx DA, Darcel Clark. But you do have the right to pursue those sexual assault charges. They're not dismissed.
And Reverend Mann, if I can just briefly add, and this has been a tremendous panel, and I regret that I have to depart momentarily, though I was originally scheduled with a pre-existing commitment at 1, but it was such a compelling discussion that I couldn't break myself away, but now we'll have to momentarily. But I look forward to continuing this discussion under your leadership, the leadership of Reverend Trufant, with my good friends and colleagues in government. But I will add, on this question, we are working in Congress with Brian Stevenson, of course, one of the foremost advocates for criminal justice reform, to address the question of prison rape, both in terms of the prevalence of it and assault, and changing some of the laws that were first put into place in 1996 that prevent individual victims from being able to seek justice on the civil side, both in the context of the perpetrators and the conditions that have turned a blind eye to allow violent sexual assault to take place, in large measure, I believe, because of who's being victimized. And now that we've got a triangular alignment of values between the House, the Senate, and the presidency, shout out to Joe Biden and Kamala Harris, I believe that we have the capacity to really change the laws in this area so that victims can find some measure of justice.
As the public advocate, I challenged the Department of Corrections because they did not report rape crimes. It's really critically important that we have transparency and accountability. Now that I represent the state of New York and now represent State Department of Corrections, I'm looking into whether or not they too are in fact following the law and reporting sexual assaults in their correctional facilities. And then two, with the question that was asked, there's a question with regards to the statute of limitations. And again, I would urge Mr. Sears to again bring his concerns to District Attorney Gonzalez and also to Darcel Clark. But it's important that individuals understand that we are in Brooklyn. We're blessed to have a progressive leader like Eric Gonzalez. There are 62 counties across this state. And even if you go to Queens, or if you go to the Bronx, or if you go to Staten Island, or if you go to New York County, it's different. It's totally different. The application of law is different. How they analyze the cases are different. How they treat defendants is different. We are blessed to have this progressive leader in Eric Gonzalez, but it's important that individuals understand that there are 61 other counties, and it's not a uniform system by no stretch of the imagination.
Wherever possible, I'll try to combine questions. David Walker had asked, if you decline a lawyer, how quickly will a new one be assigned to you?
It's usually up to the judge. It's particularly if you are assigned what they call a 18B attorney, which is a private attorney, but acts as a public attorney and our legal aid. And usually it's up to the judge, and you have to make an application to the judge. You basically have to make a plea to the judge that in fact, the attorney that is representing you, one, is not representing you adequately. The attorney that is representing you is not being aggressive, is ignoring facts. There's a fundamental disagreement. It has to be laid out factually as to your differences with the attorney that is denying you justice.
Thank you. We have a question. Do all cases come to the desk of the DA? Then why should innocent people be asked to plead guilty if they're going to end up in jail regardless?
So the majority of the cases, the majority of criminal cases come to our office now. Not all. As part of the Raise the Age legislation that I supported, if you're under 18, a lot of those cases now will be handled by family court. So that includes both, that's mandatory for all misdemeanors. For felonies, if it's a non-violent, it's mandatory. And if it's a violent felony, I can apply for jurisdiction on it. I can ask the court for jurisdiction on it, but it's ultimately up to the youth part judge. So about 93% of the time, I defer all prosecution of 18 and under to family court. I really only keep homicide charges and top level sexual assaults or really vicious pattern type cases. But it's, so that's an important component. In terms of plea bargaining, I've tried to put in mechanisms within our local justice system to prevent people from feeling forced. And so one of the major things that I've done is prevent my prosecutors from making ballooning offers, which are like, it's 3 years today, it's 15 years tomorrow. And that is what was very common in the past in our justice system. I think, Mr. Sears for sure talked about it, was like, I can take, 10 years now and maybe have to serve up to 30, or I can get 30 years and have to do the rest of my life. That seems to be, the type of thing that we're trying to prevent, so that plea bargains aren't forced upon people. There's another important thing that we can do, and it would take obviously legislative action, is we can ask our legislators to think about mandatory minimums. The reason why plea bargains are so coercive, it's not really because of, people are afraid to go to trial. It's because if they're found guilty, the mandatory minimums on these cases will send them to spend, decades in jail. And so, for example, we have a number of mandatory minimums depending on what your criminal background is, the type of crime it is. There's a lot of different factors, but mandatory minimums to me are the single biggest driver of mass incarceration, because your lawyers will say you better plead to something low because you're found guilty, you're going to get triple the amount of time or double the amount of time. So I support removing mandatory minimums and giving judges discretion in what's fair and just.
Thank you. Kyle G has a question about how can we ensure AI and face recognition technology is used responsibly in policing?
So let me just say, there has been a lot of criticism of facial recognition, particularly as it relates to people of color. Facial recognition incorporates algorithms, and within the algorithms, there's certain biases. There have also been cases where the facial recognition has been wrong, particularly as it relates to people with dark skin. So it's important that individuals understand that facial recognition is not the answer, because built in those algorithms are inherent biases. And so although we are moving now towards smart policing and more technology, we have got to analyze all of this artificial intelligence, which is now being incorporated into policing. And again, the historic relevance of policing and race, the intersection between policing and race. And lastly, let me also say this mass incarceration that we talk about relates to historically this tough on crime political position. It's politics. The reason why there's mass incarceration is not because, there's so many individuals committing crime. It was politics. It was intentional. It was deliberate. Mass incarceration going from Nixon to Reagan to even Clinton. That's resulted. You'll see the explosion of people of color, Black people in particular. If you go back and you analyze history, particularly as it relates to when we, after, during this, from slavery to the time of Reconstruction to today, mass incarceration politics. It goes hand in hand.
And 100%, I agree with our Attorney General on that important issue, because it really comes down to equal justice and fairness. And too many people have benefited from mass incarceration. I want to say another thing. It's why district attorneys are important in this situation. So in terms of the artificial intelligence or looking at this, I will not allow my prosecutors to use that in their trial. We'll use it as an investigative lead, to see, get information, but we will not take a case to trial if the only evidence is this computer saying that's the right guy. I just don't allow that in my office. And because of what our Attorney General said, we know that there's too many errors in that issue. So I'll accept it as a lead to do more investigation, but I will not use that as primary evidence at trials. And that's the discretion that I have as district attorney.
Thank you. There was a question submitted when Mr. Rivers was speaking about would it have been easier or more advisable for him to have just done the DNA test?
I'm going to say no. I'm going to say no, because that puts a burden on him to prove his innocence. That's a conversation that he could have with his attorney about what their strategy would be, but I would not put the burden on any person accused of a crime to have to, take scientific tests and to do other things to prove their innocence, as opposed to the burden being on the prosecutor to prove their guilt. So while I understand the thought behind it, if you're innocent, submit. I don't think that's the standard by which we should be expecting people to behave. And quite frankly, there's a huge trust issue, right? Do we really trust that we're going to give them their DNA, and they're going to do the right thing with it? So I say no.
So, Reverend Trufant at the beginning acknowledged the Innocence Project, and I too want to acknowledge the Innocence Project. It has resulted in the release of countless number of people of color based on their DNA. And I obviously respect District Attorney Gonzalez, but I guess Mr. Rivers at the time needed to prove his innocence. And had he had the ability, one, to analyze the DNA, and two, to confront the individual who was accusing him of that violent crime, perhaps the outcome would have been different.
Thank you. For AP Stembridge, do you have anything that you want to add to that?
Yeah, so when it comes to reviewing things, again, it always to me goes back to the evidence. So you have to have corroborating evidence as well when it comes to cases. So just like DA Gonzalez said, if you just have one piece of evidence, like one, computer telling you that this is what happened with the person, and that's not something that, frankly, I would proceed with, and I'm not aware that my supervisor would even sign off on, or my office for that matter. You have to have corroborating evidence when it comes to those types of things.
Thank you.
And I'm sorry, there is one other thing regarding DNA. So at the time of both of their cases, I don't know what the databases were like there in New York, but I know in New Jersey, back in I think around 2004 or 2005, they have databases where if, you have already been through the system, they collect your evidence for certain reasons, and they may already have it. So sometimes people, may be cleared that way when it comes to DNA as well.
So in New York, we've got databases too. There's databases from individuals who are convicted of felonies and certain misdemeanors.
Alvin Brown submitted a question: to reinforce the right that a civilian is not obliged to respond to the questioning by the police officer, what about making freely available officially issued cards which a civilian can choose to carry around to show the police officer their rights in such situations?
I believe there was a bill that was introduced by then Councilmember Jamani Williams, a Bill of Rights, which officers would have to have cards basically advising individuals of their rights. I believe that was challenged by, it was passed, but I believe it was challenged by the police unions, and I believe it's still pending in court.
I think that's right, but that does not prevent private and other organizations from making sure that people have a Bill of Rights card, which I think is important. And one of the things that, even as the DA, when we go into our schools, we try to educate our young people about their rights. I think the justice is best served when people are aware of their rights, and so I think it's a great idea.
Mm-hmm.
It was a question submitted by Lucille Dandridge. In both of the cases recounted by Ruben Rivers and Roosevelt Sears, it seems like the public attorneys did not fight for their innocence. Getting a top attorney usually means big money. How do you address that? Is the answer to hold the public attorneys to a higher standard, or to have law firms do more pro bono work, or another option?
That's a good question, and I don't want to castigate all public defenders. I was a public defender. I was a member of the Legal Aid Society. I had a winning record, and then got burnt out. And at that point in time, realized I didn't want to hurt anyone, and it was important for me to step aside. A lot of individuals, like I said, don't recognize their limits, and when they should step aside, they don't become very effective. But I do agree with you. We need to raise standards. We need to ask private attorneys to do more. And particularly during this time when individuals are struggling with COVID-19 and people are unemployed, private attorneys need to do more and more and more and more as part of the continuing legal education process, which is required under the law in the state of New York.
And one of the things that I do as DA is I testify in the city council every year to make sure that our public defenders in Brooklyn, Legal Aid, and Brooklyn Defender Services get more and more resources. I think our justice system is better served when we have great advocates on both sides. The people who, prosecutors need to be held accountable, and our defenders need to be held accountable. I will put in a plug for our defenders in Brooklyn. I think the overwhelming majority are dedicated, hardworking people, but there's some whose time has come and they should step aside. And like anything else, I said this earlier, and I'm going to kind of double down on this. Not every criminal case is the same. If you're being charged with a very complicated white-collar crime, you want someone who specializes in that kind of work. If you're handling, different types of cases, you need to interview your lawyer to make sure that you're technically the client. You are the client, right? You have to interview your lawyers to make sure that they have the experience needed to handle your case. If you're being charged with a case and you ask them, have you ever had a case like this? And the answer is no, you don't want to be the guinea pig on that.
Thank you. Skipping ahead for 1 second, we had an anonymous question. It was mentioned that we should not speak with the police without a lawyer. If they stop you and ask to see your ID, what steps should you take in that process? Should you show your ID, and then what do you do next? Do you ask if you're under arrest? Do you stop talking? What is the process you recommend?
I would recommend you show your ID. Under some circumstances, you do not have a lawful reason to ask. They don't have a right to see your ID. You can ask them if, why. And then from there, you're going to have to use your best judgment, because sometimes they're just going to walk away if you refuse it. And other times they're going to put cuffs on you. They do have a right to see ID under very broad terms, but they have to have some reasonable suspicion to stop you in the first place and ask for your ID. That's considered a second level tiered stop. They can always ask to speak to you. You have the right to say, I don't want to speak to you. I don't want to show you my ID, and you can legally walk away. And if they don't have more than, some sort of hunch, or they can't legally stop you from doing that. However, if they claim that they have reasonable suspicion, they can stop you, cuff you, and force you to do this. So it's complicated. It's complicated. My basic advice would be, I would say, why are you stopping me? And if they don't give you an answer, say, I don't want to talk to you, and keep it moving.
Yeah. The United States Supreme Court, Terry versus Ohio, gives the police broad discretion to stop you based on suspicion. So there's the legal talk and then there's the real talk. So the legal talk is you can obviously ask them why they're stopping you, and you can refuse to give them your identification. Let's be honest, ultimately it may result in an arrest. They usually will charge you with what I call catch-all crimes, disorderly conduct, resisting arrest, obstructing governmental administration, so crazy stuff like that. What we've got to do in communities of color is there is just too much police contacts in communities of color. And as a result of that, it results in mass incarceration of more people in the criminal justice system. And what we've got to do is, again, try to avoid and reform the system to reduce the number of police interactions with civilians, particularly in communities of color, not only in the city of New York, but in the state of New York. It results, again, in high incarceration arrest, and most importantly, it results in a lot of fatalities.
Oh, another question. What about a pilot program where there's available in precincts legal aid for those arrested who are unable to call for help at the time of arrest that would ensure that the arrested person's rights are verbally and in writing clarified in the presence of the officers at this stage in the process?
That's a good idea. I don't see any problems with that. It's a problem. It's a program that would have to be initiated in coordination with the Legal Aid Society and NYPD. We need to, again, begin those discussions and perhaps put that proposal out there for discussion as we as a city are about to vote for a new mayor. A lot of these programs need to be put before all of the candidates who are running for mayor. We need to make sure that we know who we elect as judges, because one actor that's not part of this discussion today are judges, and we elect them. And we need to know those candidates and what they stand for in their positions. So judges, then who the next mayor is, and then we need to bring in the Legal Aid Society and the chief, Chief Harrison, who is the head of Brooklyn North here, the first Black woman, as well as Brooklyn South, and our precinct leaders, and have discussions. Maybe we can do a pilot program here in the 88th precinct.
I know that we are running low on time, but there was a question, but what groups can people join to help and make an impact on these issues that we've been discussing today?
Since I don't, my office primarily deals in mostly civil cases. We have a limited criminal jurisdiction. DA Gonzalez, sort of.
I mean, this is the format. I think that, you know, through different ministries in our churches, through different community-based organizations, I have neighborhood safety councils that advise me on you know, what it takes to feel safe and what it takes in terms of reforming policing and prosecution functions, getting involved in those kind of things. I think that these are important conversations. It's one of the reasons why whenever I'm invited to these things, so that I can hear directly from people impacted by our justice system, you know, it's one of the most disconcerting pieces in this time is that somehow we hear from people who say, because we want to have our civil rights protected, that somehow means we're anti-police. We're not anti-police. We understand that policing is important to keep us safe, but we want the same type of policing that other people get and have. And, you know, the conversation is just so clear that, you know, our interests don't seem currently adequately taken care of by the way our system is structured. And so these conversations and all of your input and all of your activism will help us get to a better place. So continue to speak out, continue to do this, reach out to my office in terms of things that you're looking to see me do, because a lot of the things that I do in Brooklyn, we're not doing anywhere else.
I want to thank you all for answering the questions. Unfortunately, because of time, we have to move on to the next item. But for the attendees, there will be a recording that will be made available soon that will probably be on our website and on our social media platforms. So I turn it over now to Reverend Anthony Trufant.
Thank you so very much. And I want to be clear about some of the takeaways. One, I heard, be respectful of police, but keep your mouth shut until you speak with an attorney. Two, be the driver of your case, although be willing to partner with an attorney. And then three, petition legal aid or court for an attorney that is more to your liking if you are paired with someone with whom you cannot work. And then four, make sure that you see the evidence and the evidence against you. And that should happen in the process of discovery, although we know that sometimes information is suppressed. But nonetheless, those are some of the takeaways. I want to thank all the panelists. I want to thank, excuse me, first and foremost, I want to thank our AG, and I want to thank our DA. I want to thank the congressman in his absence. I know he had to leave. And I want to thank Attorney Sherry, who's also a member of EBC, and I thank you for taking out your time to be with us. And in particular, I want to give a special thanks to both Ruben and Roosevelt. Your stories were very compelling, and I want you to know that, excuse me, that what you shared with us is not only private that you made public, but it's sacred because God was at work in those stories. And so I just want to thank you for being willing to share. I also want to thank the team, Jocelyn Minister Mann, who handled many of our tech issues, Caroline, who has been with us before, who helped us actually on the last thing we did with the annual church meeting. And that was such an incredible help. So thank you, Caroline. Reverend Steph Weathers, who was my dreaming partner for this forum. I want to thank him for his input. And then finally, my co-host, Jocelyn Walters, for her sweat equity. And to the panelists, you made this experience a very rewarding one. I'm going to ask that you become evangelists and share what you have heard today with others. And I'm sure that it will prove to be beneficial to them.